Before this hearing even begins, the court is about to deal with a case that mixes alcohol, reckless decisions, and a moment that could have easily turned deadly. The defendant is only 21 years old, but today he's facing serious felony sentencing. The big question is, will the judge believe this was just a young and dumb mistake, or something far more dangerous?
Is that Mr. Walden? Okay, let's call that for Mr. Keel. Next, we've got sentencing and People v. Blaine Waldy. This files 25-7097 and 7098. Counsel, you want to state your appearances, please?
Wayne County Prosecutor.
William Keel on behalf of Blaine Waldy.
All right, and we're here for sentencing in 7097 for dangerous weapon charge, 5-year statutory max, 0 to 9 guidelines range. 7098 is assault, great bodily harm, 10-year statutory max, 10 to 23 advisory guidelines range. Have you had a chance to review the report and recommendations with your client?
I have, Your Honor.
Any additions or corrections?
No objections to the narrative portion. I do have a scoring challenge on case number 7098FC.
Right here, the defense is challenging something called a sentencing guidelines score. In simple terms, those points determine how much prison or jail time someone might face. If the defense succeeds in lowering the score, the sentencing range could drop significantly. It may sound technical, but these small numbers can literally mean months or even years of freedom.
Okay, and what guideline are you scoring?
Your Honor, I'm going to challenge the 5 points being scored on offense variable number 12. I believe that was scored due to count 2 of the information being dismissed, reckless driving causing serious impairment of a bodily function. Obviously, the question on that particular challenge is whether there was a serious impairment of bodily function to the victim in this case. Based on the evidence that I've seen, I don't think there's been any evidence presented anywhere to indicate there was an impairment of the bodily function as a result of this case. And I believe with the lack of that element of that particular charge, then that's not a felonious criminal act against a person that took place within 24 hours of the sentencing offense. So I believe that should be scored at 0. And that would change the guideline range from where it currently is at C4 to C3, and it would change the guideline range from 10 to 23 to 5 to 23 on that particular case.
Ms. Goodrich, people's position?
Your Honor, Mr. Keogh did make me aware of that objection just today. The victim was not intending to be present or make a statement. I guess I would need his testimony as to the serious impairment. I do have a couple pictures of the injuries that he incurred when he was dragged by the vehicle. But as far as how that affected his life, I would need his testimony.
Okay, well, I'm going to sustain the objection for an alternative reason.
I'm sorry, what's that, Judge?
I'm going to sustain the objection for an alternative reason and score OB12 at 0 points. I'm going to assume as true that the prosecutor could establish the serious injury, but the OB12...
Now the judge steps in, and this is where things get interesting. Instead of siding with one argument completely, the judge uses a different legal reasoning altogether. The court says the incident may involve harm, but legally, it was one continuous act, not separate crimes. That subtle distinction changes the guideline score and could directly affect the final sentence.
And that was also charged as reckless driving causing serious injury. And even though he could be convicted of both of those offenses without violating double jeopardy, they resulted from a single continuous felonious act, and there wasn't a separate felonious act. So I would score OB12 at 0 points for that reason. And Ms. Goodrich, do you agree with Mr. Keogh's math at 31 points, level 3 and 5 to 23?
Yes.
All right. Any other challenges, Mr. Keogh?
No, Your Honor. Thank you.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
Oh, yeah.
Mr. Keel, go ahead.
Is this allocution?
Yes.
Judge? I have gotten to know the Waldy family quite well over the time I've been in Sheboygan, and I know his father Jeff, who's currently in the courtroom in the back row, and he is currently the owner of a True North building, and Blaine is one of his two sons, and Blaine is quite a nice young man. He's very personable, very likable. Unfortunately, I think what these two cases have shown is that when he drinks alcohol, he does some, quite frankly, pretty reckless things. And I think both of these cases mixed alcohol with a young guy, generally a good guy, but when he mixed the alcohol, he did some pretty thoughtless things. Clearly not thinking about other people and how his behavior could affect other people. The more serious of the two cases, I'm not going to go into detail, but there's a lot of weirdness associated with what happened that day on a lot of levels. And I'm not justifying any behavior in any way, but I think there was a series of bad decisions that led to the victim getting on top of the vehicle and Mr. Waldy, my client, driving the vehicle in a way to force him off the hood of the vehicle. The victim fell and was injured, albeit, and it's our position here, the injuries did not rise to the level that would have supported count 2 that was dismissed as part of the plea agreement. He's a good guy. He's been great in the jail. He's worked for his dad in the past. We don't know if the court is inclined to give him any additional jail time. There is a county jail cap. This is not a violent person who did a violent act. This is a young person who did a foolish act that turned out to be violent. I think he's served about 5 months of incarceration already. He would really like to try to get back to work. He would like to work for his father. We would ask the court to consider time served up to this point. He's already served 5 months as of today, I believe, right on that time frame. I believe he was arrested on September 11th. I think he would have already served the minimum amount required by the guidelines. If not, we would ask the court to consider work release in this matter. I would indicate that I don't think he's a threat to the community in any way. I think any kind of sentencing condition that would require testing for alcohol and drugs would satisfy public safety in that regard. And the testing, if he was on work release, would be handled by the testing they do at the jail. So I think what you're looking at is young and dumb, and I think that's exactly what we have here. I don't think it's young and evil or young and violent. And I would appreciate if the court saw him for what he is, which is a nice guy who did some pretty foolish things. I thank the court.
After the legal debate, the courtroom shifts to something much more personal. This is called allocution, the moment when a defendant gets to speak directly to the judge before sentencing. Sometimes these statements can influence a judge's decision, but the big question is, will this apology feel genuine enough to matter?
Both situations were completely immature, unjust, and not who I am whatsoever. I'd like to let both those parties know that I do attend every church and AA program that the jail offers, not because I was told that I have to, but because I genuinely want to better myself from these situations in any way possible, to make sure that this behavior is not a repeatable act for myself. And I could never truly express how sorry I am to both the community and Mr. Savage, and I can only hope that one day I can gain the forgiveness. As well as when I get back out to the community, I just wish to be able to show the true side of myself, which is hardworking and kind, not the side that's immature, trying to impress a bad group of people that I don't normally surround myself with. And lastly, I just like to apologize to my friends and family for letting them down and disappointing them. They know who I am. They know that I'm smarter than this, a lot better of a person than this, and I did not do very well showing that. And I just once again wish to apologize to everyone for the matter. And that's all, Your Honor.
All right, thank you, sir. Ms. Kivich, any recommendations?
Yes, Your Honor, thank you. We're here for two separate cases. First, on September 5th of 2025, a Snapchat was viewed where it showed the defendant shooting a firearm out a moving vehicle on Straits Highway near Fernelius Toyota. When Mr. Waldy was approached by law enforcement, he did voluntarily come in and give a statement and admitted to his actions. However, only 6 days after that, defendant then was with a group of friends. They go to the victim's boat to consume alcohol. The defendant realizes that one of them is underage, asks them to leave. He views the defendant throwing a bench in the water, then pursues the kids. And as they're leaving, gets on top of the vehicle, on top of the hood. Originally, Mr. Waldy was not the first driver, but asked to drive the vehicle. They switched drivers. Caleb Waldy then was swerving right and left to get the victim off of the hood of the car. He was successful. The victim slid off the hood of the car, was dragged next to the tire in the car. This was caught on video. The victim suffered injuries that required hospitalization. What's concerning is the kids in that car were later found that night at Speedway, just ordering pizza after all that occurred. The defendant is 21 years old. He has no prior felonies, 1 prior misdemeanor. He's unemployed with an 11th grade education. The guidelines are 0 to 9 and 10 to 23. We did come up with the agreement of a county jail cap. That was in consultation with the victim. He just did not want to see Mr. Waldy go to prison. So I would ask the court to follow the PSI recommendations for 10 months jail with 2 years probation. This easily could have been a prison case. However, all the things that Mr. Keogh had mentioned, as well as my allocation, were considered. Thank you.
Thank you, Mr. Waldy. If you please stand for the first sentence.
Now we're at the most critical moment of the hearing, the judge's sentencing remarks. Judges often use this moment not just to punish, but to send a message. And in this case, the court is clearly concerned about reckless behavior, alcohol abuse, and the risk this posed to the entire community.
Put Mr. Savage at risk, but as you recognize today, the whole community. And we just can't have a town where people are riding up and down with cars, shooting a gun out the window. That's not the community that everybody wants. Or riding down the road, somebody on your hood trying to knock them off for whatever reason they're on your hood. That's not the kind of community we want. We've got a lot of young people in this community. We expect them to not act like this. We all know young people do dumb things, but they don't do these things. So you made some spectacularly bad decisions. And there was a serious risk of harm. And there's a lot of alcohol use going on with that for such a young man. You've got some, sounds like some good family support, good prospects for employment. But I'm concerned about the alcohol use and the reckless behavior as the prosecutor outlined. I think, these decisions that you made, don't have to determine the course of your life, right? You're only 21. There's a lot of good things you can do with your life. I want to make sure that we get enough of a handle on it right now that you're done, because these, as your first felonies, you're on a fast trip to prison unless these are your last felonies, right?
Yes, sir.
So I'm going to place you on probation in both files, but it's going to be for 3 years. I want to make sure that we've got Mr. Waldy to his mid-20s on a good track. You're not eligible for early discharge from probation, at least in 7098, because it's an assault with great bodily harm. So that's 3 years probation, subject to the terms and conditions listed on pages 2 and 3. I want to highlight some of those. There's substance abuse assessment and counseling. You're going to have a curfew. You can't use anything as a weapon, can't possess any weapons. You have to keep and maintain a job. In Agent Young, I do want to add a term that I want him to complete his education, GED or otherwise. I want you to get a high school equivalency, either finish your diploma or get a GED. There's a state cost of $68 in 7097, $68 state cost, 130 crime victims assessment. In 7098, there's $68 state cost, 130 crime victims assessment, 350 court costs, and $60 DNA testing fee. And honestly, this is the kind of behavior especially with the risk of harm to somebody and the reckless use of that firearm, that absent a county cap, I would give some thought. I'm not saying that I would send you to prison, but it'd be a tough decision I'd have to make. So I think I'm more comfortable with that county cap, and I'm going to assess the full amount, 12 months.
So here's the final outcome. The defendant receives probation along with jail time and strict conditions, including alcohol treatment and education requirements. It's a sentence designed not just as punishment, but as a warning. At only 21, the judge is essentially telling him, this is your last chance to change direction before prison becomes the next stop.
I have no objection if the jail determines him eligible. He can participate in CBT programming in the jail, counseling class that can earn time off your sentence, and the GED program where you can turn time off your sentence for GED, and or the jail trustee program. All right, so Mr. Walde, if you want to file an, and also, are there any weapons that we have to forfeit or no? Did he have
I
any?
believe they're owned by a co-defendant.
Okay, so we don't have to do a forfeiture in this file?
Correct.
All right, and Mr. Walde, if you want to file an application for leave to appeal, you can do so. If you wanted a lawyer, you'd have to either hire your own or ask me within 6 months. We're going to hand you a copy of that appeal paperwork in both files. Ask you to initial one for us so that we have a record that we gave it to you, and the other ones for you to fill out if you want to take an appeal. Within 24 hours of your release, I want you contacting your supervising agent, okay? Any questions for me? No, sir. Okay, good luck.
Just to clarify, no work release, but the.
Yes, no work release, but I'll allow programming in the jail, all available programs.
Very good. Thank you very much, Ernie.
Right, and I've got Mr. Grable and Mr. Hilliker, so I'm going to bring them both in on Zoom here. Talk with counsel, and counsel is going to request the Cobb's evaluation. I didn't feel comfortable with that today. He might consider getting me some more information about the case and requested an adjournment. Any objection to that adjournment, Ms. Goodrich?
No objections.
We'll continue this then to March 10th at 10:50 a.m. It'll be in person. And Mr. Hartman, it's not required, but if you wish to submit a memo in support of a Cobb's request, you can do so.
Thank you, Your Honor.
Okay. All right, see you then, sir.
Yeah.
And then this will bring us to our Mr. Winger with Mr. All right, up next, people be Gavin Wenger, file 25-7079 FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Flint County Prosecutor.
Thank you, Honor. Reverend Murthy, on behalf of Mr. Wenger, who's here.
Well, actually, can I, LCD Baker, is he here?
He's not here. I haven't seen him. He's not in the hallway.
Why don't we call that case real quick, 25-7081, people be LCD Baker. I've issued a bench warrant. He had failed the test. And we're here for the sentencing. There's a show cause, there's an outstanding warrant, and he's not here today. So I guess we'll just leave it in warrant status and let you know if he's in custody, then we can go from there.
Okay, thank you, Judge.
Okay. All right, so then we'll recall people be Winger. Sentencing on felon in possession, 5-year with a couple misdemeanors attached, 10 to 23 guideline range and a county cap. You had a chance to review the pre-sentence report?
I did, Your Honor. I reviewed it with my client. We don't have any corrections. I think the guidelines are accurately scored as well. I do have some attachments for the court to review. I just provided those to Ms. Goodrich as well.
Okay.
If I could approach Judge.
Yeah, you can hand those to the bailiff, please.
They're his assessment from Harbor Hall. He's done 2 of them. There was a follow-up assessment on the 26th of November.